Okay, let's dive into one of the trickier corners of negligence law. We're talking about proving fault when, well, the specific careless act is kind of invisible.
Mhm.
We are talking about res ipsa loquitur, the thing speaks for itself.
Exactly. It's really the ultimate tool, I'd say, for plaintiffs who are dealing mostly with circumstantial evidence. Think about it. If you're injured by, say, a falling object or a sudden mechanical failure, and you know the defendant was responsible for the thing, the apparatus, but you can't actually peek under the hood, you can't see the exact moment, maybe they failed to tighten a bolt, RIL lets the jury infer that, yeah, negligence must have occurred.
Right, so our mission today is to figure out the conditions, the requirements needed to invoke this pretty powerful doctrine, and maybe more importantly, to analyze how modern state tort policies, specifically thinking about comparative negligence, actually force this doctrine to radically evolve. We'll be charting this transformation through the Connecticut Supreme Court's big ruling in Giles v. City of New Haven.
That's right. We'll look at the three classic conditions needed for RIL, but we'll pay, very close attention to how Giles redefined control and fundamentally tweak the requirement about the plaintiff's own fault. This case is just crucial because it shows how courts sometimes have to adapt their interpretations to follow what the legislature intended.
Okay, before we get into the elevator crash facts of Giles, let's maybe nail down the basics first. Why did courts even invent this special rule for negligence? Like, what legal gap does res ipsa loquitur actually fill?
Well, it fills the evidence gap, the evidentiary gap. In, standard negligence cases, the plaintiff has to prove four things: duty, breach, causation, and damages. RAL helps with that second one, the breach element, but circumstantially. If you can show the accident probably wouldn't have happened without some kind of negligence and the defendant was, responsible for the dangerous thing involved, the law allows the jury to infer a breach of duty without needing that smoking gun, that direct proof of carelessness.
Okay, got it. And what are the three explicit conditions, the sort of black letter rule required to invoke this inference of negligence?
So the general rule is that RIL lets the jury infer negligence if three scientific conditions are met. And they all sort of point towards the defendant as the most probable source of the carelessness. First, the situation or the apparatus causing the injury, it has to be one where, just in the ordinary course of things, no injury would typically happen unless there was some careless construction or inspection or maybe usage. Second, both the inspection and the use must have been, at the time of the injury, in the control of the party being charged with neglect. And third, the injurious event or condition. It must have happened irrespective of any voluntary action by the injured party at that time. Now, in this Giles case we're looking at, the real tension, the core dispute, lies in those last two elements, control and voluntary action, especially since the plaintiff was actually using the thing that failed.
That's the perfect setup then. Let's analyze Giles v. City of New Haven. So, first things first, what are the legally dispositive facts?
Okay, so the plaintiff, she was an elevator operator. She got injured when the elevator's very heavy compensation chain just violently broke free. It happened after it got hooked on a rail bracket. And the cause, it was this massive, excessive sway. We're talking up to 18 inches, which is way more than the normal 1 or 2 inches of movement. The defendant here was Otis Elevator Company. And they had this exclusive, long-standing contract for all the maintenance, the inspection, and the repair of the elevator, including that specific chain assembly.
So Otis basically built, or at least maintained, the very thing that failed.
Yeah.
What was the defense argument then? The one that led to the trial court initially directing a verdict against the plaintiff.
Well, the defense pointed the finger straight back at the operator, the plaintiff herself. Their maintenance supervisor testified, basically saying the only way to generate that kind of extreme sway was if the operator was doing rapid reversals of direction. So, they argued, her voluntary action caused the crash, or at the very least, it broke Otis's necessary control over the situation. Now, the plaintiff, she countered that. She testified she was operating the elevator normally right up until the severe shaking started.
Okay, so a classic blame game.
Yeah.
And what was the core legal issue that the Connecticut Supreme Court ultimately had to wrestle with?
Yeah, the precise legal question was really whether the plaintiff had presented enough evidence to satisfy RIL's second condition, this modern idea of control/responsibility, and the third condition, absence of plaintiff responsibility. Enough evidence, that is, to survive the defendant's motion for a directed verdict. Basically, could a jury reasonably find for her based on RIL?
Right. What rule of law did the court apply then? Could you state the full black letter rule and maybe break it down into its testable elements as the court saw them?
Sure. The court applied the standard three-part RIL doctrine we just discussed. But the rule applied on appeal was whether the facts, when viewed in the light most favorable to the plaintiff, could reasonably let a jury conclude that the defendant's negligence is the more probable explanation for the injury. The whole analysis really hinged on how they redefined control in Element 2 and, critically, how they had to modify voluntary action in Element 3 to make it fit with the state's comparative negligence statute.
Thank you. That clarity is helpful. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element in dispute? Control, which is element 2.
Okay, so the sub-issue here was absolutely critical. When a defendant, like Otis, has a maintenance contract, but the plaintiff is the one actively using the device at the time of the accident, does that use destroy the defendant's necessary control for RIL? Well, the court strongly cautioned that the term exclusive control can often be, frankly, misleading. The sub-rule they really endorsed is that the key question isn't about who had physical hands on the controls at the exact moment of injury. Instead, it's about who had the responsibility for the condition that actually caused the injury. The plaintiff just needs to bring forward enough evidence so a jury could reasonably infer it's more probable than not that the defendant's negligence was the cause.
That feels like a really significant clarification. But wasn't the plaintiff the one physically operating the control? She was causing the movement, right? Why did the court kind of disregard that immediate physical control?
Because the failure wasn't just about operation, it was systemic. Otis controlled the maintenance and repair of that compensation chain, its bolts, the whole setup. That chain assembly was supposed to handle normal operational stress. So the court reasoned that even if the plaintiff's operation contributed somehow to the sway, a jury could still reasonably find Otis negligent for the chain's underlying faulty condition, the condition that allowed such excessive sway in the first place. The responsibility for preventing that kind of defect, that stayed with Otis because of their contract. So therefore, the court concluded element 2 was met. Responsibility for the instrumentality's underlying condition rooted in that exclusive maintenance contract was enough to satisfy the control requirement, even with the plaintiff operating it.
Fascinating. So the maintenance duty creates the control, essentially, regardless of who's flipping the switch at the moment. So, okay, now what about the second element in dispute? Absence of voluntary action by plaintiff, element 3. The defense was arguing her rapid reversals were a clear voluntary action causing the crash. How did the court handle that possibility, the plaintiff maybe being at fault?
Right. This was where policy really collided with the old precedent. The sub-issue was, does a plaintiff's potential contributory negligence still act as a complete, absolute bar to even applying RIL, especially after the state legislature has adopted comparative negligence? And the court saw this as the major policy hurdle they had to clear. The sub-rule they effectively established formally modified that old RIL Condition 3. They pointed to the legislative adoption of the comparative negligence statute and said, look, the whole purpose of that statute was to get rid of the harsh old common law rule, the one that completely barred recovery if the plaintiff contributed even just 1% to their own injury.
So wait, if the legislature passed a law specifically designed to apportion fault, divide it up rather than just block recovery entirely, then requiring the plaintiff to prove they were completely blame-free just to use the RIL doctrine seems like it would directly undercut that law, wouldn't it?
Absolutely. That's exactly what the court concluded. They stated pretty clearly that requiring a plaintiff to be entirely free from fault as a prerequisite just to invoke RIL, that would directly contravene the obvious legislative purpose. The common law, they said, needs to harmonize with these statutory schemes. So therefore, the court concluded that element 3 is satisfied if the evidence simply shows the defendant's inferred negligence was more probably than not a cause of the injury. Any potential negligence on the plaintiff's part, it becomes irrelevant to the initial RIL inference itself. It only gets factored in later under the comparative negligence rules to potentially reduce the final damage award she might receive.
Wow. Okay, so after that really quite sweeping realignment of RIL with modern tort policy, what was the court's final conclusion on the Giles case itself?
They affirmed the appellate court's decision, which had reversed the trial court's directed verdict. Basically, they said the evidence did establish a reasonable basis for a jury to potentially find Otis Elevator Company negligent under RIL, because the plaintiff's potential fault is now handled separately under comparative negligence, reducing damages, maybe, but not blocking the initial inference the case had to go to the jury. The plaintiff deserved her day in court on that theory.
That shift, going from exclusive physical control to exclusive responsibility for maintenance,
Right.
That really seems like the legal money shot here, the core takeaway. Let's try to lock it in with a scenario, maybe something more visceral.
Okay, let's do it. Bring on the scenario.
All right, imagine you are a listener. You're hosting a huge neighborhood barbecue. Big event. You just rented a brand new, fancy, professional grade deep fryer from, let's call them Deep Fryer Pros Inc. DFPI. Now, DFPI gave you a certificate explicitly stating they have exclusive responsibility for maintaining the internal thermostat and the oil temperature control systems. Critical parts. So you are operating the fryer perfectly. You set the temperature correctly, you carefully drop in the food, everything seems fine. But suddenly, that certified thermostat catastrophically fails. The oil overheats, ignites, and burns your arm. Pretty bad. Now, DFPI argues, hey, you were in control because you were using the fryer at the time. If you sue DFPI using RIL, would their argument about your use defeat the control element based on Giles?
Following the logic and the policy laid out in Giles. No way. That argument completely fails. Spectacularly, I'd say. Because the court, as we saw, isn't looking at who was physically dropping the food into the oil at that moment. It's looking at who had the non-delegable duty, the responsibility, over the specific component that failed. DFPI had that exclusive contractual duty to inspect and maintain the crucial, specialized part, the thermostat. And a thermostat failure like that, that's precisely the kind of thing that usually doesn't happen unless there was some careless inspection or maybe faulty construction. So, since DFPI maintained that exclusive responsibility for the defect, the RIL inference points squarely at them as the most probable cause of the failure. Even while you were just operating the machine normally for its intended purpose, your act of using it doesn't just magically strip them of responsibility for a latent mechanical failure they were supposed to prevent.
Huh. So the fryer is, like you said earlier, literally speaking for itself about DFPI's likely negligence, regardless of whether I was standing right next to it operating the controls. That definitely makes the modern RL rule seem far more practical.
Well, it really has to be practical, doesn't it? Otherwise, the whole doctrine probably would have just withered away and died once comparative negligence became the norm. Because, let's be honest, almost every plaintiff has some kind of minor contribution, however small, to the chain of events leading to their injury. So, okay, if you are going to apply this modern doctrine of res ipsa loquitur successfully, especially thinking about exams or analyzing a case in a comparative negligence jurisdiction like Connecticut was in Giles, you really need to follow this kind of four-step diagnostic checklist. Step 1, event check. First off, does the event itself clearly suggest that someone must have been negligent? You know, like a falling brick from a building or a part breaking that just shouldn't break under normal use, a sudden explosion. If the event could easily happen without any carelessness, RIL just doesn't apply. It's barred from the start. Step 2, instrumentality.
Yeah.
Next, clearly identify the specific mechanical part or system that seems to have failed or caused the problem. Be precise. Was it the elevator compensation chain, the certified thermostat in the fryer, the faulty wiring? Pinpoint it. Step 3, responsibility control. Then, determine if the defendant was responsible for the condition or the maintenance or maybe the construction of that specific instrumentality. Does the evidence make them the more probable source of the negligence? And crucially, remember, Giles, the plaintiff's simple act of using the instrumentality at the time generally does not defeat this element anymore. Step 4, plaintiff fault integration. Finally, if it looks like the plaintiff might have contributed somehow to their own injury, maybe they were a little careless too, do not let that block the RIL inference itself. The inference still applies because the focus is on the defendant's probable negligence being a cause. The plaintiff's fault, that just gets factored in later under the comparative negligence rules, usually to reduce the final damage award.
That synthesis really captures it. That's the aha moment from Giles, isn't it?
Mhm.
RIL isn't some rigid mechanical obstacle course designed just to throw plaintiffs out of court anymore. It's evolved into a more flexible tool, focused pretty firmly on finding the most plausible source of negligence based on responsibility.
Exactly. You can almost say it's a policy doctrine kind of wrapped up inside an evidentiary rule now. It serves a broader purpose.
Okay, and that actually leads to a really deep policy question for you, the listener, to maybe mull over later. Since Giles was sort of forced to modify the third element of RIL, the plaintiff's contribution part because of the comparative negligence statute, what happens, or what should happen, to the first element? That original requirement that the event must ordinarily require carelessness to happen. If a jurisdiction were to adopt pure comparative negligence where theoretically a plaintiff could recover even if they were, say, 99% at fault for their own injuries, does that original quite high bar for RIL still make logical sense? Should RIL's use maybe be broadened even further to cover events that are perhaps only slightly more likely than not due to carelessness, if we're already comfortable awarding some damages to a plaintiff who is almost entirely at fault? Where should that policy line truly be drawn now? Something to think about.